presentation. I'd like to pass it over to one of our Employment Development Department representatives, Hans Hoagland, to get things started. Hans?
Hello, welcome everybody, and thank you, Megan. My name is Hans Hoagland, and I'm a payroll tax specialist with the Employment Development Department, and I'm happy to be with you here today. Also presenting from EDD is Harpreet Sheena. Harpreet, please introduce yourself.
Hi, good morning, everybody. My name's Harpreet Sheena. I'm a payroll specialist with the EDD, and I'm also happy to be here today. And I will go ahead and turn it over to Vaughn from the Labor Commissioner's Office.
Good morning to everyone. My name is Senior Deputy Boinger with the Labor Commissioner's Office. Also happy to be here today. Want to commend you all, take a moment just to commend you all for being here with us today, wanting to learn about our laws. As Megan has already said, we've got folks here from all over the countryside. And in fact, I think we even have participants from Canada today. So just know that we have got a lot of information for you today. We're happy to present it. And with that, I also want to introduce our attorney for the Labor Commissioner, Miles.
Yes, hello, my name is Miles Locker. I am an attorney for the State Labor Commissioner. I am looking forward to this presentation. I hope you all are too. And yeah, maybe we'll all learn something today. Excellent, bye.
Perfect. Thank you, Vaughn, Miles, Hans, and Harpreet. Just a couple of housekeeping items before we get started with our presentation, which is scheduled from 10 a.m. to 12 p.m. Pacific Standard Time. We are going to be taking one 10-minute break midway through the presentation, so please just stay logged in and muted during the break time to avoid any technical issues. For questions, please provide them as a direct chat message to me, Megan Lopez. The presenters are going to address the questions related to the topics that they're going to be covering at the conclusion of the presentation during our question and answer session. Please keep your electronic devices muted throughout the presentation to avoid any unexpected background noise. And as promised, I'm going to be providing the presentation slides handout as well as the resource link document in the chat box. Those are being downloaded, looks like successfully now at 10:07. And if you haven't already addressed those 4 questions that were on the opening slide, I'm going to go ahead and put those in as well now. Anything else I missed, Vaughn, before we move on?
No, Megan, I think we've got it. And with all things, there are disclaimers. Today's no exception. The information provided today is a public service and intended to provide non-technical assistance to everyone. Every attempt has been made to provide information that is consistent with the appropriate statutes, rules, administrative, and court decisions. Any information that is inconsistent with the law, regulations, and administrative or court decisions is not binding on either the Employment Development Department, the taxpayer, or the Division of Labor Standards Enforcement. Therefore, any information provided today is not intended to be legal, accounting, tax, investment, or other professional advice. And the Labor Commissioner's overview is this, that the mission of the California Labor Commissioner's Office is to ensure just days pay in every workplace in the state and to promote economic justice through robust enforcement. We have several units that handle different types of enforcement within our Labor Commissioner's Office. And by combating wage theft, which might be something like not paying your employees or not paying minimum wage, these things can be felonies now as the first of the year. We're protecting employers from retaliation and educating the public like we are this morning. We put earned wages in the pockets and help level the playing field for law-abiding employers, which is to say that if you are a law-abiding employer, you are paying your folks what you're supposed to, when you're supposed to, you've got workers' comp, you're following all our rules, regulations, and laws, and there is an unscrupulous player out there who may be underbidding you because they are not playing by the rules, we want to know about it. Therefore, you can email us at makeitfair@dir.ca.gov. Again, that is makeitfair@dir.ca.gov. And now something really important that everybody should know here in California. The workers in California have the right to file a wage claim when their employers do not pay them the wages or benefits they're owed. A wage claim starts the process to collect on those unpaid wages or benefits, and California's labor laws protect all workers regardless of immigration status, which is to say that if you are working here in California, you have rights. Hans?
Hi again, everyone. Thanks, Vaughn, for the important info about the Labor Commissioner's Office. I will also provide a quick overview of the services provided by the EDD. So the EDD is one of the largest state departments, and we offer a variety of services to Californians. We administer the unemployment insurance, state disability insurance, and paid family leave programs. EDD's tax branch administers California's payroll tax program, and the Workforce Services branch connects job seekers with employers. Finally, EDD's Labor Market Information Division is the official source for California's labor market information. So this division tracks certain indicators such as the unemployment rate. You can learn more about EDD by visiting our website at edd.ca.gov. Let's proceed to the next slide and we'll discuss our objectives. So today you will receive information from the EDD and Labor Commissioner's Office on AB5, the ABC test, and how to distinguish between an employee and an independent contractor. We're also going to discuss multi-state employment and common wage and hour law application. As mentioned earlier, the seminar today will focus on information specific for the trucking industry. Harpreet will start with the reasons to properly classify workers. Harpreet.
Thank you. So there are a number of reasons to properly classify workers. When a worker is misclassified as an independent contractor, their access to benefits such as unemployment insurance, disability insurance, and paid family is delayed. Responsible businesses that properly classify their workers can potentially avoid audits and investigations by the EDD, the DLSE, and other agencies to prevent restitution, additional taxes, penalties, and interest from being owed. So there are two types of workers, employees and independent contractors. Employees can be further broken down as either being subject or statutory. A subject employee is a worker who is an employee based on the ABC test, the Borrello test, or another applicable test. A statutory employee, on the other hand, is an employee by law under a specific statute. In the trucking industry, for businesses which are organized as corporations, the corporate officers would be considered statutory employees. The EDD has a number of resources available for further information. I believe we provided this in your handouts and also within the chat pod. The first resource that we have available is the information sheet DE 231 SE. Covers this information sheet provides lots of useful information on the different types of statutory employees. The second one is DE 231 LLC. This information sheet covers the various limited liability entities when they're considered an employing unit and when compensation paid to members or partners are wages subject to California payroll taxes. And then the last one is the DE 231 PC. This information sheet includes specific information about payments to corporate officers and how to determine if the payments are wages. Next, Hans is going to review the history of employment determinations.
Thanks, Harpreet. So how a worker is determined to be an employee versus an independent contractor has evolved over the years. Employment status in California up until AB5 and the ABC test was based on the multi-factor common law test, which evolved over time through various court decisions. I'm going to now provide you with an overview of common law in California. So one of the earliest decisions used to determine the status of a worker is Empire Star Mines, which was issued in 1946. And under the Empire Star Mines case, if the employer retains the right to control the manner and means of accomplishing the desired result, the worker would be an employee. Subsequently, in 1970, the T-Berg decision was issued, and the decision provided specific secondary factors to consider in making a status determination. Fast forward 19 years, and the California Supreme Court issued the decision in the Borrello case. The Borrello test is referred to as a multi-factor test because it requires consideration of all potentially relevant facts, and no single factor controls the determination. Over time, courts have emphasized different factors in the multi-factor test depending on the circumstances. The California Unemployment Insurance Appeals Board, which is the administrative authority for EDD benefit and tax appeals, issued precedent tax decision PT 511. I wanted to mention PT 511 because this precedent decision analyzes common law for owner-operator truck drivers in determining if the owner-operators are employees or independent contractors. PT 511 also analyzes multi-state employment in determining which state the employer must report the wages when a truck driver provides services in California and other states. We will discuss multi-state employment a little bit later in this presentation. And a link to PT 511 was included in the resources handout, and I believe it will be also put into the chat pod. Next slide, please. All right, so common law was used to determine if a worker is an employee or independent contractor for decades. Then in April 2018, the California Supreme Court used a three-part test, which we now know and refer to as the ABC test. In this decision, which found that Dynamex Operations West misclassified its workers as independent contractors. This decision became known as the Dynamex case. When Dynamex was issued, it was for purposes of wage orders only and did not apply to EDD to determine the status of a worker. Shortly after the Dynamex decision was issued, the California legislature introduced Assembly Bill, which we call AB5, to codify the Dynamex ABC test for all employment status purposes in California, not just wage orders. On September 18th, 2019, the governor signed AB5 into law. To summarize, AB5 codified the ABC test from the Dynamex case for all employment status purposes in California, and AB5 took effect for some purposes January 1, 2020. After AB5 became law, there were many bills introduced in the legislature to modify, replace, or even repeal AB5 in the ABC test. One of these bills is AB 2257. AB 2257 was signed by the governor on September 4th, 2020, and the bill recast, clarified, and expanded the ABC test and exceptions under AB5. In the time since AB5 and AB 2257 became law, there have been other bills targeting AB5. AB 1561 is one of these bills, and the bill made other minor changes to the exceptions from the ABC tests. Next slide. All right, so what exactly is the ABC test and what is a subject employee versus an independent contractor? Looking at this slide, an individual who performs services or labor is presumed to be an employee unless the hiring entity can prove the worker meets all three conditions of the ABC tests. So there is a presumption the worker is an employee, and if the hiring entity does not demonstrate that all three conditions are met, the worker is an employee. Alternatively, if the hiring entity demonstrates that all three conditions are met, the worker would be considered an independent contractor. But I want you to keep in mind there are exceptions to the ABC test for certain categories of occupations, industries, and contracting relationships. Today, we will be discussing the ABC test in detail since the test pertains to most workers in California. Next slide, please. As just mentioned, under the ABC test, a worker is presumed to be an employee unless the three conditions are all satisfied by the hiring entity. And I'm going to briefly cover each of the conditions now, and then we'll go into them in more detail on subsequent slides. For the first condition, the individual is free from control and direction. Next, the individual must perform work that is outside the usual course of the hiring entity's business. Finally, the individual has their own independently established business. So I wanted to mention, like I said on the earlier slide, while the ABC test is applicable for most workers, for some jobs, industries, and contracting relationships, there are exceptions from applying the ABC test. Each exception has criteria, and if the criteria are satisfied, the employment status of the worker is typically determined using the Borello test or another test. Additionally, the ABC test does not apply if a court of law issues a ruling that it does not apply. There is currently a court of law ruling involving a preliminary injunction in the trucking industry, and we will discuss this further a little bit later in the presentation. And Harpreet will now start with a discussion of condition A. Harpreet.
Thanks. So since the ABC test is new in California, the best way to understand its application is to analyze the dynamics decision that Hans just reviewed with us. So I'll be doing a little bit of that today. So condition A states the individual is free from control and direction, both under the contract and in fact. So when we look at dynamics case, the California Supreme Court explained that a worker who is subject to the type and degree of control a business typically exercises over employees is considered an employee. So the hiring entity must establish that the worker is free of such control to satisfy condition A of the ABC test. The court provided 3 examples from other states applying condition A of the ABC test, and I'm going to go ahead and review 2 of those with you. The first case is Western Ports Transportation, Inc. versus Employment Security Department. This case is from the state of Washington. Western Ports Transportation, Inc. was a trucking firm with operations in Washington and in California. In this case, the hiring entity required the driver to keep their truck clean, obtain the company's permission before transporting passengers, go to the hiring entity's dispatch center to obtain assignments that had not been previously scheduled, and the hiring entity could terminate the worker for being late, for failing to contact the dispatcher, or for any other violation of the company's written policy. The court held that the company failed to establish the truck driver was free from its control due to everything that the hiring entity required of the driver. The second case is Great Northern Construction, Inc. versus Department of Labor. This case is from the state of Vermont. This case involved a worker who specialized in historic reconstruction. The worker set his own schedule, worked without supervision, purchased all materials he used with his own business credit card, and declined an offer of employment by the hiring entity because he wanted to maintain control over his own activities. In this case, the court held that the worker was sufficiently free from the company's control. So I've reviewed 2 very different cases in 2 different industries to demonstrate how condition A is applied. So under condition A, the hiring entity must demonstrate that the worker is free from control and direction, both under the contract and in fact. Next, Hans is going to review condition B of the ABC test.
Thanks, Harpreet. For condition B to be met, the individual must perform work that is outside the usual course of the hiring entity's business. For the analysis of this condition, first determine what the hiring entity's usual course of business is, then determine what the worker is doing. Finally, make a determination whether or not the worker's services are within or outside the hiring entity's usual course of business. If outside, if the other 2 conditions are met, the worker would not be an employee. However, if not outside the usual course of the hiring entity's business, the worker is an employee. I wanted to note, if any one condition is not met by the hiring entity, the worker is an employee. Not all conditions need to be analyzed. On the flip side, All three must be met for the worker to be considered an independent contractor. As shown in the second bullet on the slide, Dynamex explains workers who provide services in a role comparable to that of an existing employee will likely be viewed as working in the usual course of the hiring entity's business. Next slide, please. This slide further explains how to determine if the services are outside or within the hiring entity's business. These examples are from the Dynamex court decision. The first set of bullet points are when the services are not part of the hiring entity's business. And I'll summarize those for you. When a retail store hires an outside plumber to repair a leak in a bathroom on its premises, or hires an outside electrician to install a new electrical line, the services of the plumber and electrician are outside the scope of a retail store. Alternatively, the Supreme Court also provided examples when the services are within the usual course of business for the hiring entity. And when a clothing manufacturing company hires seamstresses to make dresses that will be sold by the company, or when a bakery hires cake decorators to work on a regular basis on its custom designed cakes. The Dynamex decision also provided 3 more examples from other states applying Condition B, and these examples can be found in the footnotes in the Dynamex case. Up next, Harpreet will provide information on Condition C.
Thank you. Condition C states the individual has their own independently established business of the same type as the work performed. This means that if the worker is providing services as a plumber, they actually have a separately established plumbing business. So in Dynamex, again, the court explained that there's more to being an independent contractor than simply the name. The hiring entity cannot just label the worker as an independent contractor or require the worker to enter into a contract which designates the worker as an independent contractor. This is something that I've seen quite often here at EDD. I've interviewed workers who've stated, well, they told me I was an independent contractor, or I had to sign an agreement in order to work and provide for my family. So again, the court said that you cannot just arbitrarily do that. Additionally, the court stated the fact that a business could come into existence in the future is not sufficient. Condition C requires that the worker's business actually be in existence when the services are performed. The court stated that an individual who independently has made the decision to go into business, generally they'll take certain steps to establish and promote that business, meaning like they would incorporate, obtain a license, advertise their services, offer services to a number of potential clients, use their own tools and equipment, have their own place of business. Next slide, please. Something else to consider is that just because a hiring entity has not prohibited the worker from engaging in an independently established business does not mean that Condition C is satisfied. This is also something that I've seen quite often when I interview business owners. They'll tell me, well, I didn't stop the worker from having their own business. And also, just because the worker could have engaged in an independently established business, but in fact did not, does not mean that Condition C is satisfied. So again, we go back to Dynamex. There were 6 cases cited within Dynamex from other states applying Condition C of the ABC test. I'm going to be sharing just one of those with you today. The case is JSF Promotions, Inc. versus Administrator. This case was heard by the Supreme Court of Connecticut. So JSF engaged the services of individuals called demonstrators to hand out samples and coupons to customers. They would contact the demonstrators and advise the demonstrators of the time and place of the demonstrations. They required the demonstrators to sign an independent contractor agreement. They determined the rate of pay. They did not provide any documentation that the demonstrators were in business for themselves. The demonstrators did not have business cards. And the demonstrators stated that they did not contract with other entities to perform the same services, but they had signed an agreement with JSF, which stated that they were independent contractors. The court held that the fact that the hiring entity allows a worker to engage in similar services for others is not sufficient evidence to demonstrate that the worker is customarily engaged in an independently established business. So under condition C of the ABC test, the business must be established independently of the hiring entity or the rendering of the service. Next slide, please. We're going to move right into the exceptions from the ABC test. So Labor Code sections 2775 through 2784 established exceptions for certain occupations, industries, and contracting relationships. This means that there are some situations where the ABC test may not apply. Each exception has very specific criteria that all must be satisfied. If all required criteria are satisfied, then the working relationship will be determined using the Borello test or another test. If all criteria are not satisfied, then the ABC test is to be used. You can visit the employment status portal to view the list of exceptions. The link for the portal has been provided to you in your reference material. I just want to point out that it's important that meeting the requirements for an exception does not mean that the worker is an independent contractor. Rather, the exception allows for use of the Borello test or another test in lieu of the ABC test for most exceptions. Next slide, please. So the exception that I will be reviewing with you today is the business-to-business contracting exception. This exception is pursuant to section 2776 of the Labor Code. So the business-to-business exception only applies if 12 criteria are all satisfied. If the 12 criteria are all satisfied, again, it does not mean that the worker is an independent contractor. Rather, instead of the ABC test, the multi-factor Borello test will be used to determine the employment status. If all criteria are not satisfied and there are no other applicable exceptions or court of law rulings, the employment status will be determined by the ABC test pursuant to California Unemployment Insurance Code section 621B. So this exception applies to the relationship between a business service provider and a contracting business. A business service provider is an individual who is acting as a sole proprietor or a business entity formed as a partnership, a limited liability company, limited liability partnership, or a corporation. An example of a business service provider could be a truck driver. On the other hand, a contracting business is another business with whom this business service provider contracts to provide services or is a public agency or a quasi-public corporation. The contracting business may also be referred to as the hiring entity, especially in the criteria that I'll be reviewing a little bit later today. An example of a contracting business could be a trucking company. On the next slide, I'm going to go ahead and review the 12 required criteria with you and how the criteria may apply in the trucking industry. And just to remind everybody, you can view the exception and the criteria by visiting the employment status portal. And the link has already been provided to you. It's in the resources as well as in the chat pod, excuse me. So the first criterion is that the service provider must be free from the control and direction of the hiring entity, meaning the business for which the services are performed regarding the performance of the work, both under the contract and in fact. So this is condition A of the ABC test that I discussed earlier. In the trucking industry, the trucking company that contracts for the services must not only have a contract that states that the truck driver is free from their control and direction, but the truck driver services being performed must actually be free from the contracting trucking company's control and direction for this criterion to be satisfied. Criterion number 2, the service provider must provide services directly to the hiring entity rather than to its customers. In the trucking industry, an example of this could be when a large chain store contracts a truck driver to transport loads from a warehouse to a retail location. In this scenario, the truck driver is providing services directly to the hiring entity, which is a large chain store. However, this requirement does not apply if the service provider, which could be a truck driver, has employees and the employees are solely performing the services under the name of the service provider and not the contracting trucking business, and the service provider regularly contracts with other businesses. Number 3, the contract with the service provider is in writing and specifies the payment amount, including any applicable rate of pay for services to be performed, as well as the due date of payment for such services. Number 4, if the work is performed in a jurisdiction that requires the service provider to have a business license or business tax registration, the service provider meets these requirements. To confirm whether a business license or business tax registration is required in a jurisdiction, you can visit calgold.ca.gov. This website can assist in finding appropriate license, registration, and permit information based on industry and location. Number 5, the service provider maintains a business location, which may be the service provider's residence, that is separate from the business or work location of the hiring entity. In the trucking industry, this means that the truck driver has their own business location, which could be their residence. The driver may even consider the yard where they park their truck the location of the business, as long as it is separate. It is a separate location from the hiring entity or the contracting business. Number 6, the service provider is customarily engaged in an independently established business of the same nature as that involved in the work performed. This is condition C of the ABC test that I discussed earlier. So in the trucking industry, the truck driver must actually have a trucking business. If the truck driver does not have a trucking business and instead has a different type of business, for example, the truck driver has a retail store, this criterion would not be met. Next slide, please. Number 7, the service provider can contract with other businesses to provide the same or similar services and maintain a clientele without restrictions from the hiring entity. Number 8, the service provider advertises and holds itself out to the public as available to provide the same or similar services. Number 9, consistent with the nature of the work, the service provider provides its tools, vehicles, and equipment to perform the services, not including any proprietary material that may be necessary to perform the services under the contract. In the trucking industry, this could mean that the driver provides their own truck or tractor to perform the services. The driver may even have their own trailer, and other equipment could potentially include, for example, a dolly, jack, and electronic equipment such as a tablet. Number 10, the service provider can negotiate its own rates. Number 11, Consistent with the nature of the work, the service provider can set its own hours and location of work. And last but not least, the service provider is not performing the type of work for which a license from the contractor state license board is required. So as I mentioned earlier, if the 12 required criteria are satisfied, then the working relationship will be determined using the Borello test and not the ABC test. If all criteria are not satisfied, then the ABC test is to be used if there are no other applicable exceptions or court of law rulings, which Hans is going to review with you next.
Thank you, Harpreet. As mentioned earlier, included in AB5 and now published in the Labor Code is a provision stating if a court of law rules the ABC test does not apply in a certain context, instead, the multi-factor Borello test will apply. One example of a court of law ruling is the preliminary injunction, which prevented AB5 and the ABC test being applied to determine the status of truck drivers. I just want to give you a brief history on the injunction. This preliminary injunction was granted on January 16th, 2020 by a U.S. District Court in the California Trucking Association, CTA, v. Bonta case on the basis of CTA's argument that AB5, which is a California state law, is preempted by the Federal Aviation Administrative Authorization Act, which we refer to as F4A, which is a federal law. According to the injunction, the EDD and other state agencies are temporarily enjoined from enforcing Assembly Bill 5's ABC test as to any motor carrier operating in California pending the entry of final judgment in this action. After the injunction was granted, the decision was appealed to the Ninth Circuit Court of Appeals. The Court of Appeals reviewed the case, and on April 28th, 2021, the court issued a ruling that overturned the injunction. However, the injunction was allowed to remain in place while the CTA pursued a writ of certiorari to the U.S. Supreme Court. On June 30th, 2020, the U.S. Supreme Court denied the motion to hear the case. Next, in a hearing on August 29th, 2022, just very recently, the U.S. District Court entered final judgment in the case pending lifting the injunction. The injunction temporarily prevented the application of AB5 and the ABC test while it was in place, except for claims based on an Industrial Welfare Commission wage order for which the Dynamex case applies. Instead of the ABC test, the multi-factor Borello test was applied to determine the status of truck drivers as either employees or independent contractors. In light of continued uncertainty, we intend to apply both the ABC test and the Borello test in the alternative to all pending matters from AB5's effective date until courts resolve this uncertainty. Next slide. There are situations where there are multiple entities who could potentially be the correct employer. The correct employer would be the entity responsible for reporting the employee's wages to the EDD for purposes of unemployment insurance, state disability insurance, employment training tax, and personal income tax withholding. There are 4 scenarios as shown on the slide where the California Unemployment Insurance Code provides guidance to determine the correct employer. The first scenario involves a situation when you have a worker who hires a helper. So for this scenario, there's 3 parties in the relationship. You have the hiring entity, the worker, and the helper hired by the worker. If the worker is found to be an employee of the hiring entity, what happens to the helper? Would the helper also be an employee? If so, who's the employer subject for payroll tax reporting purposes? It is the Section 606 of the Unemployment Insurance Code provides the authority for this scenario. Under Section 606, if an employing unit has actual or constructive knowledge of a hire helper by a worker found to be an employee, whether or not the employing unit hired or pays the helper, the employing unit is the employer of the employee or helper. I will provide an example to help explain the scenario. In the motor carrier industry, it is a common practice for truck drivers who own a truck referred to as first seat drivers to retain the services of a second driver referred to as a second seat driver to take turns driving the truck. The motor carrier trucking company has constructive knowledge there are two drivers, as the nature of the work is not possible to be completed by one driver. If the first seat driver is determined to be an employee of the motor carrier trucking company, applying section 606 of the California Unemployment Insurance Code, the second seat driver would also be an employee of the motor carrier trucking company. The next scenario on the slide is for how to determine if an entity is considered a temporary services employer, or which we also commonly refer to as a leasing employer. So in this relationship, you have the temporary services leasing employer, you have the client or customer, and you have an employee. The code lists 7 criteria. If there is a contract to supply a worker and the entity performs all 7 of the criteria, the entity is considered a temporary services leasing employer and is responsible for reporting the worker to the EDD for payroll taxes. If there is no contract to supply a worker and or the hiring entity does not perform all 7 of the criteria, the entity is not considered a temporary services leasing employer and the correct employer has not been determined. There are a few more scenarios that are applied to determine the correct employer. If the 7 criteria for the temporary services leasing employer are not met, and if there is a contract to supply a worker, the entity is not considered a temporary services leasing employer. They're considered the agent of the employer, which is the 3rd bullet point on the slide. And they're considered the agent if they are paying the worker. So in this scenario, the correct employer is the entity where the worker is providing services, and the entity supplying and paying the worker is the agent of the correct employer. The final scenario on the slide involves the loan of an employee from one employer to another employer. This code section is applied to determine the correct employer when you have 2 entities who are employers and the worker, the employee. For this scenario, the entity who's paying the employee is the correct employer responsible for reporting the employee for payroll taxes. For additional information on determining the correct employer, when there are multiple entities involved, refer to information sheet, employer determinations, multiple entities, which is the form number DE231F. And a link is included in the resources handout, and I believe it was also just put in the chat pod. Let's now proceed to the next slide on multi-state employment, which is relevant to the trucking industry since many truck drivers start and end their route in California and travel in many states. This topic is applicable anytime a worker provides some services outside of California. Section 602 and 603 of the California Unemployment Insurance Code provide the application of 4 tests to determine if services are subject to California law for payroll tax reporting. This is an important topic for the trucking industry because many truck drivers do not provide services solely in California. Rather, they start in California, then they crisscross across the country many times before heading home to California. To summarize, an employee services outside of California are not subject to California payroll taxes, which include unemployment insurance, state disability, employment training tax, unless some portion of the services are provided in California. So some of the services have to be in California. Please note, personal income tax reporting requirements are different than the requirements for unemployment, state disability, and employment training tax. And I will discuss the personal income tax next. The 4 tests are similar to the laws in other states to prevent overlapping coverage, meaning the employee's wages should only be subject to payroll taxation in one state rather than various states for any time frame. And I'll briefly review the 4 tests. So the first test is localization, which is where the services are localized. Second, base of operations, which is where the employee is based or where they begin and end their services. 3, place of direction and control, which is where the employer is based and direction controls the employee from. Finally, residence of the employee, which is where the employee lives. These 4 tests are applied in descending order. So you start with localization, then based off operations, and so forth. If a determination can be made on the first test, the analysis stops. If a determination can't be made on the first test, you proceed to the second. You keep doing the analysis until a determination is made. For future reference, refer to the information sheet on multi-state employment, which is the form DE231D. And this has additional details about the 4 tests, including examples on how to determine which state must report the worker's wages. As mentioned earlier, the PIT withholding and wage reporting requirements differ from those for unemployment insurance, state disability insurance, and employment training tax. Wages paid to a resident employee for services performed within or outside California, or to a non-resident employee for services performed within California, are subject to California personal income tax withholding and reportable as PIT wages. The DE231D information sheet, which I mentioned earlier, has additional information and provides examples for determining when to withhold and report the personal income tax for non-resident employees. On the next slide, the Labor Commissioner will provide information on multi-state employment that's specific to the DLSE. Vaughn, I'll hand it over to you.
Thank you, Hans. So with regards to multi-state employment and the Labor Commissioner's Office, AB5 is applied if the statutory claim at issue is an example, minimum wage or reimbursement of business expenses is decided under California law. Now, court cases establish that the test for determining whether California law applies to work performed out of state or doesn't apply to work performed in the state is that the test is one type of claim may differ from the test for another type of claim. And that is to say that essentially we take each claim on a case-by-case basis, and something that might sound exactly the same to you in your situation, but just an if, and, could, or may would change everything. Therefore, that's why there may be a different test for another type of claim. And if all work is performed in the state, California applies to all claims. And if the work is performed in multiple states, California will apply, law will apply to all in-state work for many types of claims, including minimum wage and expense reimbursement. California law may also apply to out-of-state work if over 50% of the driver's work time is in California, or driver starts or ends trip in California, and there is more work time in California than any other single state. And the driver's residence or motor carrier's domicile are not considered in determining applicability of labor codes and the IWC wage orders. And what you're looking at here is one of the better websites. It's not because I work for the Labor Commissioner's Office that I think this, but it is actually one of the more useful websites out there for gaining information. If you had questions, you go to the dir.ca.gov/DLSE, Division of Labor Standards Enforcement webpage that you're looking at here. If you had a question, like maybe going, want to know about alternative work weeks or overtime in California, or any number of other questions you might have, you would just go to the top right there at the query box and put in the simple thing you might want to know about wage order 9, for example, and information will come up. It will most normally answer your questions. Now, if you still have questions after you've done your research and check, you can go to our labor law tab over here. If you were to click on that, what it will do is it'll tell you where the city and state and county, actually city and county here in California that you're performing the duties at. And you can click on it and it will tell you which one of our offices is in the jurisdiction of where your business or question is located. And along with that comes with the contact information and email abilities. Just know that we get about 70 calls an hour into our offices. We don't have 70 offices, so we're allowed 48 hours to respond, and we do respond. But if you need something a little sooner, then go to the query box and you will get the information you need. And now, as for independent contractors here in California, it's probably good to point out, especially to those employers outside California, that you could be in compliance with the EDD, you could be in compliance with the Franchise Tax Board, but if you're not in compliance with the rules, laws, and regulations of the Division of Labor Standards Enforcement, you may not be in compliance. In other words, you have to be in compliance with all three entities. And the differences may be small. There's some nuances, but just know that you'll want to check with all three entities to make sure you're in compliance. Now, with regards to independent contractors, it does prohibit willful misclassification. In other words, you knowingly have put people in as an independent contractor when they are not. Prohibits in engaging in pattern or practice of doing something like that. And I mentioned early on that we have different units within the Labor Commissioner's office. Most commonly, visitor to your business would be somebody from our Bureau of Field Enforcement, where they would be looking for pay stubs. They'd be looking for employment records. They will be looking to see if you're misclassifying your employees as independent contractors when they really just aren't. And it prohibits charging a fee or making a deduction to individuals that have been misclassified. In fact, I've actually seen a case where a trucking company was charging this new employee for the workers' comp, the higher premium of workers' comp, because they brought him on board. You can't do that. All these things are subject to civil penalty and requires notification and website notice. And also know that there is a statute of limitations. As noted, Dynamex applies to all alleged violations of IWC wage orders back to the statute of limitations for that claim. Statute of limitations applies from the date the wage claim is filed. Very important that you know that with the Labor Commissioner, or the date that the Commissioner's office issues a citation or files a lawsuit. It limits claims to a fixed period of time before the claim is filed. Generally, civil penalties are 1 year. Amounts owed to workers based on the violation of law is 3 years. Other types of claims like breach of contract, 2 or 4 years. Also, if it's a wage-related claim, if you have a written contract, statute of limitations is 4 years. And if it's a handshake and an application, it's 3. Now, claims regarding IWC wage order violations, minimum wage for all hours worked, overtime pay for overtime hours worked, meal and rest periods, reporting time pay, and reimbursement of uniforms, tools, and equipment. Note, certain truck drivers will be exempt from some IWC requirements. And we believe we'll go into that here in just a few moments. Minimum wage for all hours worked. Hours worked means all time the employee is work, or the worker is required or permitted by the employer to work, and 2, all the time worker is subject to the employer's control. In other words, it's really important to know that here in California, every moment you put in on behalf of the employer, and in other words, you're doing work on behalf of the employer, it's all compensable. You get paid. Time spent driving, waiting for trucks to be loaded or unloaded, waiting to enter a port facility or fueling a truck, completing mandatory paperwork or attending mandatory meetings equals hours worked and must be paid at not less than the applicable minimum wage. So in other words, anything you're doing on behalf of the employer is compensable. And you may hear me say that a couple times because I know people struggle with that. It's just anything you're doing, if the employer is asking you to do something and you're doing it, then it's all compensable time. And under California law, each unit of time or each task is considered separately and must be paid at no less than minimum wage, and there's no averaging. What that is trying to tell you is that even if you're on piecework, and it doesn't matter if you made $300 for the whole day, if you weren't making minimum wage for the first hour or second or third hour, for example, then you have to be paid minimum wage. You must adjust that piece rate to include minimum wage for all hours worked. And just so you can see here what the current minimum wage scale is here in California, If you have 25 or fewer employees, it's currently $14 an hour. If you have 26 or more employees, it's currently $15 an hour. Please know that we do realize that there are employers that kind of waver in between the 25 and the 26 employee scenario. So check our website and it will tell you exactly how to go about determining for that pay period how much your employees are to be paid. And please note that the future increases will be tied to increases in the inflation rate. And starting in 2023, the minimum wage will be the same for all employees and employers, regardless of the size of their workforce. So beware, local minimum wage rates, if higher than the state rate, will apply. And with that in mind, let's start talking about minimum wage ordinances, MWOs. This is a sample list of the cities and counties where an employee can be working, where they could be subject to being paid by the minimum wage ordinance. Now, here in California, and as in most states, everybody needs to understand that the minimum wage, there is a federal minimum wage of $7.25 an hour. Now, what that means is that an employer or a state, for example, can pay more than or demand more be paid based on the state law. For example, California has a higher minimum wage than the feds. And you can do that. You can't offer less than the $7.25 an hour, but you can legislate more. And so with California, that's why you've seen the $14 and $15 an hour minimum wage respectively. But now also just know that because of the way the same set of laws work, that cities and counties can also demand that you pay more to your employees. So you can always, again, you can pay more, but you can't pay less than the California minimum wage. So here's a sample list of counties where, cities and counties where the minimum wage ordinance exists, and they are higher. And just know that if you are in that city or county for 2 hours or more, then you would be subject to being paid the higher minimum wage based on that city and county. Now, all too often, I've seen in our hearings where an employer will say, "Hey, listen, yeah, no, we didn't pay him the minimum wage ordinance, even though they were in that city or county for 2 hours or more, because there was a traffic jam. It wasn't our fault. We shouldn't have to pay that." But that's not how it works. The way the law reads, quite simply, is if the employee is there and they're there because you told them to go there and they're stuck there longer, it's not an affirmative defense to say, well, they weren't supposed to be. Because how it reads is they were there that much longer, which means they are subject to be paying the higher minimum wage. And there are different ways of paying wages. Wages are all amounts of labor performed. Wages can be paid in many different ways, including, but just one more time, I want to reiterate that wages for all amounts of labor performed. In other words, anything you're doing on behalf of the employer is compensable. And so the different ways are hourly, daily, weekly rates, fixed amount of pay per unit of time, piece rate wages in the trucking industry, payment to drivers per load or per mile driven, or types of piece rates. The pay is based on the amount of work performed, not by the time spent working. Production bonuses, extra pay promised for meeting certain targets. And it doesn't matter which method is used, but payment cannot equal less than the minimum hourly wage for each and every hour worked. Again, maybe you made $300 for the whole day, but if you weren't making and getting paid minimum wage for the first 2 or 3 hours of that day, you have to be paid at least minimum wage. So it's not an aggregate amount, it's an hour by hour amount. And the problem with piece rates is, though a legal method of paying employees piece rates, such as pay per mile, do not compensate workers for non-productive time. So non-productive time equals hours worked that are not directly related to the activity compensated by the piece rate. For an example, the driver is paid by the mile, time spent fueling the truck or completing required work paperwork. is still going to be compensable time. So non-productive time must be paid on an hourly basis at not less than the minimum wage, in addition to the workers' piece rate earnings. And again, it's key here, in addition to the workers' piece rate earnings. And overtime exemptions for truck drivers. And so, and this is, hopefully this will clear up some of the confusion. Commercial motor vehicle drivers are exempt from overtime pay if their hours of service are regulated by the U.S. Department of Transportation, otherwise known as the DOT, or by the CHP. If hours of service are not regulated by the DOT or the CHP, the driver is entitled to overtime pay for all overtime hours worked. And DOT rules cover commercial motor vehicles with gross weight of at least 10,000 pounds, and 2 that are part of the continuous movement of goods across state lines. And CHP rules cover, number 1, trucks over 26,000 pounds, and number 2, tractor trailers over 40 feet long or at least 10,000 pounds in gross weight, and 3, vehicles transporting hazardous materials, 4, farm labor vehicles, and 5, PUC regulated vehicles. And to explain further, daily overtime, 1 1/2 times the regular rate of pay for hours worked over 8 hours and up to 12 hours in pay. And these are for drivers not covered by the DOT or CHP hours of rules of service. And weekly overtime, 1 1/2 hours of regular work for all hours worked over 40 hours in a work week. And just know that a work day is a set 24-hour period by the employer, and it's static. It doesn't change. It might be 12:01 a.m. to 12 p.m. It could be, 11:59 p.m. or I've seen it be 3 p.m. to 2:59 p.m. It's whatever it is the employer sets that 24 hours to be, that's what it is. And that's when anything you work over 8 hours in that 24-hour period is going to be overtime. And weekly is a work week is a set 7-day period. It's not, all too often, again, I'll talk to employers, what's your work week? Well, it's Monday through Friday. So no, what's your 7-day work week? No, it's Monday through Friday. No, it can be Sunday through Saturday. It can be Monday through Tuesday. It can be Wednesday through, it can be Monday through Sunday. It can be Wednesday through Tuesday. But the whole point is that it's a set static 40 hours in a 7-day period of time. So whatever that set 7-day period of time is, anything over 40 hours in that set work week is going to result in overtime. And there's 7th-day overtime on a 7th-day consecutive day worked in a work week, 1 1/2 times regular rate for first 8 hours worked, and 2 times regular rate for all hours worked above that. So these are the breakdowns of the rules. And so it's pretty standard. Anything over 8 hours in a work day or anything over 40 hours in a work week, if you are not covered under the DOT or CHP hours of rules of service, there's going to be overtime. There's actually going to be double time over 10 hours in a work day. Now, calculating the regular rate of pay. Regular rate of pay is hourly rate of pay for non-overtime work hours. Cannot be less than the minimum wage. If the worker is only paid by an hourly rate, the established hourly rate is the regular rate of pay. Piece rate, whether it's pay per mile or per load, is converted to hourly regular rates by dividing the week's piece rate earnings by week's total productive time, hours worked. If paid a daily rate, divide the day's rate of pay by 8 for regular rate. If paid a weekly rate, divide that by 40 hours. Meal
Hey,
and
hey
rest.
Vaughn,
break-
this is Hans. Sorry to cut in.
Yeah,
I was wondering if this might be a good time to give our listeners a 10-minute break.
I think you're right. Now that we are going to be moving to meal and rest periods, we're kind of changing the subject. Now would be great. So folks, why don't we go ahead? It's 11:10. We'll take 10 minutes. Please don't sign off the meeting. You can stay on the meeting. And so the idea is that we'll meet you back here in exactly 10 minutes. You can walk away from the computer. Please stay muted. And Hans is right. It's time for that 10-minute break. So we'll see everybody back in 10 minutes. Duty that can be it can be an issue. So relieved of all duty, not required to remain near the truck. If not relieved of all duty, the break is work time and must be paid. Breaks must be provided no later than the end of the 5th hour of work. And unless the driver declines and the day's work is completed in 6 hours. So in other words, if an employee does not want to take a break, then that's fine. The main thing is you have to make one available to the employee. Second meal breaks, if over 10 hours of work, driver can decline if day's work is completed in 12 hours. But know this, that if you've already waived the first one, you cannot waive the second. An employee is entitled to meal period premium pay equals 1 hour of regular rate of pay for each hour for each day the employer fails to provide required meal periods. So if, well, I won't go into detail because we've got more slides on the subject, but essentially, there is something here in California called a meal and rest period, a premium of for a missed meal or rest period of the employee's hourly rate of pay. So, and even though if it was supposed to be a half-hour lunch, they didn't get it, they are entitled to an hour's pay for the premium. And meal and rest break requirements, number 3, is that rest breaks must be paid at a regular rate of pay, and a worker must be relieved of all duty during the break, and at least 10 minutes for break for piece rate workers. The rest breaks must be paid on a separate hourly basis in amount based on the worker's regular rate of pay for productive hours. But the main thing to take the take-home message here is that you must be relieved of all duties. You can't say, hey, listen, if you're if you're sitting at the desk there, I know you're on your break and the phone rings, answer it. That's not being relieved of all duties, which means the employees are entitled to the premium. And the number of rest breaks per day depends on the number of hours worked in the day. And one break for 3.5 hours to 6 hours worth of work in a day. Second break of 6 to 10 hours worked in a day, and a third break if worked 10 to 14 hours in a day. An employee entitled to rest period premium pay, 1 hour regular rate of pay for each day the employer fails to provide a rest period. But know that in California, if you're working an 8-hour shift and you have 2 rest periods that you're allotted, if you miss both, you can only claim 1 if you're filing a claim. And reimbursement for work expenses. The IWC orders require employers to pay for tools or equipment required by the employer or necessary for the performance of the job. And the labor code requires employers to reimburse employees for all necessary expenditures incurred by the employee in performing their duties. Examples: fuel, truck lease fees, tolls, vehicle insurance costs, cell phones, etc. Reimbursement is due no later than the payday of for the pay period when expenses were incurred. Meaning that I've seen employers have claims filed against them where they said, well, you didn't turn in the form, you didn't turn in the expense report form, so we didn't pay you. Well, that isn't how it works. Here in California, the employer either knows or should have known that there are being expenses paid. on behalf of the employer by the employee, and that at the very least, you have a duty to inquire of the employees what those expenses are so they can be properly and paid timely for any expenses that they have incurred on your behalf. Itemized wage statements must be provided to the worker whenever wages are paid, and the employer must keep and make available to the worker on or the labor commissioner for at least 3 years. The following information must be included on a pay or wage statement: employee's name and last 4 digits of the SOCH, legal name and address of the employer, the start and end date of the period for which the wages were paid, total hours worked by the employee during the pay period, and gross wages earned during the pay period. All deductions made from the gross wages. Net wages, remaining amount after deduction from wages, also must be noted on there, and all applicable hourly rates and hours worked at each rate of pay. Also, amounts of hours available to employees to work for sick leave. In other words, under AB 1522, you have to show what hours are available for unused paid sick leave, and employees paid by piece rates. So the statement must show that the applicable piece rates and the number of piece rate units earned. Example, 2,000 miles at 50 cents a mile. That's just an example. For employees paid by piece rates must show the total hours of compensable rate and recovery periods, and the rate of compensation and gross wages paid for those wages during the pay period. An exception does exist is if the piece rate payments are in addition to a base hourly payment of not less than minimum wage for all hours worked, including non-productive time and rest and recovery periods. But just know that, again, you'll hear us keep repeating this, but for all hours and all time worked paid on behalf of the employer is compensable to the employee. Record keeping, here is just a minimal list of the type of records that you must keep. And there's the Wage Theft Protective Act. There's got to be personnel files and employees' right to review those files. There are penalties for failure to allow employees to inspect or review personnel records or payroll records. Personnel records is $750 penalty, and payroll records is also $750. So it could be a total of $1,500 if you fail to allow employees to inspect or review their records. Retaliation. Retaliation is prohibited here in California. Labor Commissioner enforces many laws prohibiting employers from retaliating against employees who are engaging in a variety of specified protective activities. These laws are listed at the website or the URL that you see there. Protected activities include filing a claim with the Labor Commissioner, testifying at a hearing or assisting in an investigation, whistleblowing, reporting any suspected violation of law to a government law enforcement agency or a supervisor or a manager, exercising any rights under the labor code, for example, taking paid sick leave, and reporting unsafe working conditions or refusing to perform work, which would violate an occupational safety law or standard and create a real and apparent hazard to any employee. Some of this is not new. Employers have always been responsible for the safety of their employees on the workplace or during them doing work on your behalf. Workplace postings, here you see them. The IWC orders that the employees are working under where they are working at. Payday notice. This is informing the employees of when paydays are. By the way, paydays aren't, they're not roving. They're set and static, just like a work day is or a work week is. You might have it the 5th and the 20th, the 1st and 15th, etc. It doesn't mean if or kind of or sort of. It just means that's when the payday is, and there's a notice that tells employees when that payday is. The minimum wage tells you what the minimum wage is, that there's a wage theft protection template, and also notifying employees of paid sick leave that these are all things that that they must be aware of. Workers' compensation employees have to know. You have to post this where they can see it. Have to know who the workers' comp carrier is and how to get in touch with them if there's a claim. And whistleblower protections, time off to vote, and the complete listing is at the URL that you see below here. And now back to our friends at the EDD for some more information. Hans?
Yes, thank you, Vaughn. All right, so when appropriate, employers are required to provide EDD notices and pamphlets to each of their employees. I'll briefly review the ones listed on this slide. The DE 2511 is a paid family leave brochure that outlines the paid family leave program. Next, DE 2515 is a brochure for the state disability insurance program. Next, the DE 2320, titled For Your Benefit, California's Programs for the Unemployed, is a comprehensive pamphlet providing information on unemployment insurance, state disability insurance, paid family leave benefits, and workforce services benefits that are available to the employee. Upon separation, employers must provide employees with a written notice. Finally, when appropriate, provide employees with information on federal and state earned income tax credit. These forms, additional information about what employers must provide employees, and so much more can be found on the EDD public website. The resources handout has additional links as well. The next slide provides information on the employer requirements when employees are terminated.
And thank you, Hans. This is one of the shared slides that we have today for the Division of Labor Standards Enforcement. The termination requirements are as follows. First of all, we have to determine whether or not the separation was a discharge or a quit. And it's the difference between the labor code sections you see there. And generally, how we will go about figuring out if there was a discharge or a quit is we will ask the parties, hey, if the employee wanted to come back the next day, could they? And if the answer is no, then we're going to see it as a discharge. If the answer is yes, then we're going to see it as a quit. Just know that employees must provide the employer with at least 3 days notice of that they are going to quit. If they don't quit, if they don't give you 3 days notice, you still get the 72 hours to pay them. Just note that that 72 hours could be on a weekend or a holiday, even if it's Christmas afternoon. If that's when the 72nd hour is, you've got to have them paid by then. And if you do not, there are something called waiting time penalties. And waiting time penalties are something that if you do not pay the employee at the time of separation, in other words, by 5 o'clock that same day, if they've been terminated, for example, if you do not pay them, and the employee doesn't ask for their paycheck to be mailed, and you do it and they don't get it that same day, or if you pay them by pay card and the bank doesn't post it, there could be something called waiting time penalties. And waiting time penalties are the daily rate of pay that the employee generally earns up to 30 days. So if you take 15 days to pay your employee their final set of wages, then waiting time penalties can apply. If you pay them 45 days late, the penalty stops at 30 days. So if you pay an employee late, in other words, they have to have access, and that's why I was talking about whether you're mailing the check, the final check, and they don't ask you to, or you paying them the direct deposit or a pay card, and they don't have actual access to the wages, then waiting time penalties will apply. I've seen it be some pretty heavy numbers, so that's not something you want to do. The other thing to keep in mind is that if you call an employee in, or they show up for their 8-hour shift that day and you're waiting for them to hand them their final check, and you say you don't work here anymore, if you did not pay them for the time to show up that day, in other words, if they were scheduled for 8 hours, you have to pay them for 4. If they were scheduled for 4 hours, you have to pay them for 2. At no time can you pay them for less than 2 hours for that penalty. In addition to, and so final wages, just so you know, are all earned wages, earned wages, including all unused accrued vacation hours paid out at the employee's final rate of pay. And one thing to know that you can pay employees is you tell them and you have it in writing in advance, and they're an actual employee, you can pay them a different rate of pay for PTO or vacations. However, the final paycheck, though, has to be paid out at the final rate of pay. Hans?
Thank you, Vaughn. So upon termination, in addition to the DLSE requirements Vaughn mentioned, EDD requires employers provide employees with a written notice upon separation and provide Form DE 2320, which is titled For Your Benefit, California's Programs for the Unemployed. On the next slide, Harpreet will review some important resources from the EDD.
Thank you. So we have a list of resources available to assist employers and payroll tax professionals. The first one is the California Employers Guide. It's a DE 44. The DE 44 is published each year to help employers understand their rights and responsibilities. The second resource we have is the Employment Status Portal at labor.ca.gov/employment status. The Employment Status Portal has a variety of information for workers and employers about the ABC test, the Borrello test, and the exceptions. And the last one here is the Employment Status Tax Seminars, which is what we're attending today. The EDD offers no-cost seminars to help employers comply with state payroll tax laws. You can visit this website to register for one or more seminars. We also have several information sheets available, which we covered throughout our presentation as well. And then we have additional ones here listed for you. The first one is the DE 231. This information sheet provides information on employment, including who is an employer, who is an employee. The ABC test has a brief introduction on the exceptions to the ABC test, the Borrello test, and excluded services. The next one is multi-state employment. That's the DE 231D. As we mentioned earlier, this information sheet includes details of the 4 tests to determine in which state an employee's wages must be reported. And then the last one we have here today is the DE 231. This covers employer determinations. This is a good reference on the various scenarios to determine the correct employer responsible for reporting an employee's wages when there are multiple entities who may be the correct employer. There's also an example for each scenario. And back to Hans.
Thank you, Harpreet. And on this slide, there's some additional resources that we wanted to provide today. The first resource on this slide is a link to the California Office of the Small Business Advocate. And the website offers a plethora of information on many topics specific for small businesses, including information on government contracts, grants and incentives, required permits, and understanding government regulations. The Office of the Small Businesses Advocate has offices throughout the state with expert advisors on hand who can assist with all stages of the business, from startup business plans, obtaining financing, marketing, and more. When you navigate to the website, you can view a map of your closest technical assistance center, and they offer one-on-one appointments with the advisors. The next resource is a quick start guide. This guide is a 7-page publication offered by the Small Business Advocate that, in addition to the information and resources above, provides specific information for freight trucking businesses. In the trucking industry, there are various regulatory requirements at the federal, state, and local level, which can vary depending on the jurisdiction. This guide is a go-to source for information for these regulatory requirements. The next resource is the Trucking Incentive Guide. And this was created by the governor's Go Biz office and provides information about new and existing state funding resources available to assist California's trucking industry. Specifically, the guide includes funding and resources for owner operators seeking to establish their own independent small business motor carrier authority, funding and resources to assist trucking companies maintain and expand their trucks and associated equipment, information on helping trucking companies grow with incentives for enhancing their workforce. Finally, the guide offers other incentive opportunities such as various state income tax credits and various jurisdiction utility discounts. Let's proceed to the next slide, please.
And Hans, this one is for the Labor Commissioner's Office contact information. Toll-free number you see there is 833-526-4636. Our website is dir.ca.gov/DLSE. For email for general questions, the DLSE2@dir.ca.gov is a really good resource, and where you'll get some very good, specific, solid help on any questions you may have with regards to any of our laws, rules, or regulations. Although we will not give case-specific responses. It needs to be made clear that we will give you general information, but it will be practical general information. And emails for information to our business engagement program, otherwise known as BEP, and to contact us. And again, this is that same email address we talked about earlier. If you have an unfair player out there wanting to do something that they're breaking the laws, rules, regulations, cutting corners and underbidding you while they're doing it, we want to know about it at makeitfair@dir.ca.gov. And there's also the FAQs and questions you may have with regards to misclassification in AB5. You see that that URL there for the dir.ca.gov and independent contractors. And with that, back to Hans.
I believe this one will be Harpreet instead of me.
Thank you. I want to remind all of you of our disclaimer as we wrap up the presentation today. So this information is provided as a public service and is intended to provide non-technical assistance. Every attempt has been made to provide information that is consistent with the appropriate statutes, rules, and administrative and court decisions. Any information that is inconsistent with the law, regulations, and administrative and court decisions is not binding on either the Employment Development Department, the taxpayer, or the DLSE. Any information provided is not intended to be legal, accounting, tax, investment, or other professional advice. And with that said, I'm going to go ahead and turn it back to Megan. Thank you.